Okay, welcome back, everybody. I'm so glad people are here for this panel. We have a great panel that's lined up here today to talk about a very important issue, and I think an important piece of this puzzle, and that is the pipeline issue. We've heard about that earlier this morning. We can't very well diversify the legal profession if we don't start from the beginning, and basically starting from law school. And we probably, quite frankly, need to start in kindergarten, but I think that's another discussion altogether. But this afternoon's panel is going to examine the role that law schools can play and should play in terms of achieving a diverse legal workforce. We have some data that indicates that for certain racial groups, there has been a decline in the number of law school graduates over time, which obviously makes it more difficult to diversify the legal profession. So we're going to be taking a look at that. Our goal this afternoon is first to identify the problem, and so we'll be looking at some statistics. The second thing is to try to identify what are some of the reasons behind the trend that we see, or the decline. And then finally to identify solutions or strategies, ways that we might be able to address that problem. So it's clearly this is a complex issue. And our panelists have a tough job ahead of them, but we are very confident that they're up for the task. Let me start by introducing our panelists. And I've asked each of the panelists to take on one specific question, the three goals that I outlined for each of them to try to wrestle with that particular piece. And then we're going to open it up to Q&A and have you sort of engage with us in each one of those. Let me start off first with Conrad Johnson. He is a clinical professor of law at Columbia Law School. He is co-founded and for 11 years directed the law school's Fair Housing Clinic. So they do a lot of civil rights types of cases. He also founded the Loring in the Digital Age Clinic. So very, very interesting. He's a nationally recognized leader in innovative legal education, access to justice, diversity, and technology. He has also taught at CUNY Law School, and he received his JD from Brooklyn Law School, so really happy to have him here. Next, we have Dorothy Brown. She is a professor of law at Emory University School of Law. She specializes in tax law and critical race theory. She is well known for her work in examining the racial implications of federal tax policy. She has also taught at Washington and Lee University of Law, where she was the director of the Francis Lewis Law Center. Prior to that, she's also taught at George Mason and the University of Cincinnati. She served as special assistant to the Federal Housing Commissioner at HUD, and she received her JD from Georgetown. Thank you for being here. And then finally, we have Renee Devine. She is an associate dean for student affairs and a professorial lecturer of law at George Washington University School of Law. She has extensive experience in higher education administration. At Georgetown University, she served over 9 years as associate dean of students, interim dean of students, and special counsel. She's also served as counsel to the State Department, the U.S. Information Agency, and the Federal Reserve Board. And she also received her JD from Georgetown. All right. I don't think I introduced myself. I'm a professor here at the Columbus School of Law and very, very interested in these issues. I serve on the admissions committee and have been thinking a lot about these issues. So I'm very pleased to have been invited to moderate this discussion. So let's start off with the first question, which is really what is the problem? And we'll have Professor Conrad Johnson help us out with that.
Thank you for the gracious introduction. It's always nice to be introduced. I know you didn't intend this as the problem, but but I'll try my best to not be that big a problem. I want to thank Dean Miles and all of you for being here. I've learned a lot today already, and I'm sure I'll learn some more with this great panel. My job is to set the stage by talking about some basic information regarding legal education and diversity in legal education. And in this context, I'm going to talk mostly about ethnic diversity. So I'm sure many of you are familiar with the facts, but we thought it would be good to sort of start off on the same page. So let's talk about the profession. Oh, the wrong way. Here we go. Some people have suggested to me that I just put up this slide and sit down. This doesn't tell you what the problem is. I don't know what will. These reflect statistics from the last fully reported census, which was 2000, and the conclusions are stark. Our profession is nearly 90% white and more than 70% male. The ABA, in its Next Steps for Diversity report that came out last year, suggests that demographic projections for 2010 do not suggest that much has been achieved. The report also concludes that our profession is among the least diverse in the country, and that racial diversity has slowed since 1995. This gives you a sense of how out of balance the legal profession is, the blue with, the red with the blue with the total population, which is in red. As people have been saying all day, Michael Olivas is the last, that we're becoming an increasingly multicultural society. The Census Bureau predicts that we'll be majority-minority by 2042. The ABA Office of Diversity Initiatives notes that disparities between legal profession and the general population are on the rise, and that the proportion of minorities in the legal profession is not likely to attain parity with the general population in the foreseeable future. That said, one early conclusion I want you to understand is that if we maintain the current status quo with regard to diversity in law schools, we will find ourselves falling further and further behind if your goal is to attain parity with the general population. Back in 2006 and 2007, Margaret Martin Berry, who you have the great pleasure of having on your faculty here, was president of the Society of American Law Teachers, and she suggested that we try and amass some statistics about the state of diversity in legal education. And so we set out to do that in a study that we put up on a website that my clinic students and I worked on, called The Disturbing Trend in Legal Admissions, I believe. In any event, the original report came out in 2007. It was updated in 2009. It has attracted a great deal of attention from the Congressional Record to the New York Times. The information was based on information that was provided directly to me by folks at the Law School Admissions Council, not from their website. And this slide shows you sort of the shape of total applications over time. So just note the shape of the curve so that we can see whether or not applications from other groups sort of mimic that curve. So this shows you applications on the part of African Americans and Mexican Americans, African Americans in blue, Mexican Americans in yellow. And of course the shape of the curve is more slight because of smaller numbers, but it mimics the shape of the total applicant pool, which says that African Americans and to some extent Mexican Americans have been applying in relatively steady numbers. Among minority groups, applications from African Americans, Hispanic, Latinos, and Asian Pacific Islanders, these are all categories that come from LSAC statistics, remain strong, showing increases of 4.7, 5.9, and 5.3% respectively over 2008 figures. That's in 2009. And indeed, in the fall of 2009, applications from Hispanic Latinos represented a 10-year high. At the same time, applications from American Indian, Alaskan Natives, Chicano, and Mexican Americans are low and trending downward. There are two metrics, as you know, that loom large in admissions, the undergraduate grade point average and the LSAT. And I don't mean to concentrate on these two to privilege them in any way, because we all know it takes a lot more than a good GPA and an LSAT score to be a good lawyer. But because they loom so large in admissions, I want to talk about them a little bit. And as Michael was saying and others have said, the number of applications have risen, and understaffed admissions offices, many but not all, tend to take shortcuts, and they rank order people based on credentials rather than considering the whole human being. And things like diversity, which is found to be a compelling interest by the Supreme Court, can take a back seat to these credentials. So can other things like wisdom, collaborative skills, integrity, initiative, resilience, all those kinds of things. Okay. So this shows that over time, the GPAs of African Americans and Mexican Americans has risen. This shows that the LSAT scores have risen somewhat. I want to take a moment out just to give you some caveats about the LSAT. First of all, it's not an IQ exam. A lot of people think that's what it measures. It does not. According to the LSAC, it measures a limited set of acquired, not native, but acquired skills in reasoning and in reading and verbal reasoning. The ABA standards, Standard 503 in particular, currently require that applicants take a valid and reliable test, and the LSAT has been found to be a valid and reliable test, although in the interpretations that the ABA has issued, they say that their standard does not tell a school how much weight to give the LSAT. The school decides that. And of course, there is a real possibility that Standard 503 will be changed so that you're not required to give the LSAT, but we'll see what happens with that. Folks at the LSAC, to their credit, have cautioned folks about the misuse of the LSAT, and they've said that LSAT and GPAs only should play a limited role in the admissions process, and that they caution against misuse, mostly in the way that some schools use it as a cutoff. So if the cutoff is 145 and I got a 144, well, I'm not getting in, even though statistically, according to the psychometricians, there is no big difference between a 144 and a 145. And similarly, the other misuse is to place great significance on these differences. So when Michael talked about the websites with some of our dean friends announcing upgrades in the average LSA or the median LSAT scores, most of these changes are statistically insignificant, but folks like to rely on them. All right, let's talk about matriculation or enrollment. This chart shows that in 2000, there was the total 1L enrollment was 41,200. In the fall of 2009, the 1L enrollment was jumped up to 48,900. That's at the far right of your screen. And just to provide an update, which isn't reflected here, the class that entered in 2010, enrollment was 49,700. So right now, for the class that entered in 2010, there are 8,500 more seats than there were for the class that entered in 2000. There also, in 2000, there were 182 law schools, and now there are 200, and you heard Michael say that there are another 12 being considered. So for minority admissions, what does this mean? First, the good news. Minority enrollment in law schools has generally increased modestly and steadily over time. Data from the ABA indicates that over the most recent 15-year period for which JD enrollment figures were tracked, total minority enrollment increased approximately 4%. That's to about 21-22%. Okay. For some groups, like Asian Pacific Islanders, they account for much of the gain in the total minority enrollment. And of course, gains by any underrepresented group are to be celebrated, just as losses by any underrepresented group are cause for concern. This isn't about subtraction or division, it's about addition and multiplication. Sadly, the percentage of representation of African Americans and Mexican American law students has trended downward over time. So, for example, when one compares the percentage of African American first-year law students in 2000 with the percentage of those entering in 2009, you find a 4.2 decrease in proportional representation. And for Mexican Americans, they experienced a 26% reduction in proportional representation over the same period. So when you consider the context of an expanded pie, 8,500 more seats, and smaller percentages of people getting in, what you see is that some groups, African Americans and Mexican Americans in particular, are receiving a smaller piece of a larger pie. So, for example, according to the ABA, the prior high water mark for 1L African American admissions was 1994, when 3,600 African Americans entered the class. It was not until 15 years later, with the entering class of 2009-2010, that the ABA recorded a modest increase of 191 African American 1Ls over the 1994-95 figures. Another example is if you look back, number of African Americans in the 1L class in 1993 and compare it with the number in 2005, you see a 7.5% decrease in proportional representation. If you compare 1993 to 2009, you see almost a 10% decrease, a 9.9% decrease in proportional representation. For Mexican Americans, if you compare 1983 to 2008, you see a negative 11.7% decrease in proportional representation. And if you compare 1993 to 2009, a negative 26% decrease in proportional representation. Proportional representation is a way of illustrating the fact that African Americans and Mexican Americans account for a much smaller piece and in context of the total picture. Now, when we did this study, I was somewhat surprised by the results. And I know many people of goodwill who were also somewhat surprised by these results. And I've been thinking about why we're surprised. Okay? One is there is a tendency to conflate the improvement, the increase in total minority students with the increases or decreases for certain particular groups. And when we conflate that, we confuse things so that we don't really see a clearer picture. The second is there's been a real tendency for us to measure these things on a year-to-year basis. So you see 40 more here and 100 less there and plus 1.2% or a negative 0.9%. Who knows what that means? When you look at it longitudinally, that is to say over time and in context, you begin to spot trends that might otherwise elude you. And the last reason might be heuristics, the intuitive judgments we make based on sort of a loose set of facts. So folks look around and they see more people of color in law school, slightly more. They see an African-American president, 3 women on the Supreme Court, and there's a tendency to think, mission accomplished. And we all know that that doesn't lead necessarily to the right result. I would be remiss if I didn't talk about the 800-pound gorilla in the room, which, as we all know, is U.S. News and World Report. As an educator, it pains me to say this to you, but many, though not all, law schools have abdicated their responsibility as gatekeepers to a magazine. I just want to say that one more time, a magazine, okay? And I'm not against the magazine, I just don't think they do the job terribly well, and I don't think it's a terribly good way for us to maintain the gate. The AALS commissioned a study in 1998 called The Validity of the U.S. News and World Report Rankings of ABA Law Schools. I want to read from their conclusions. The AALS concluded, quote, 90% of the overall differences in ranks among schools can be explained solely by the median LSAT score of their entering classes. And essentially all of the differences can be explained by the combination of LSAT and academic reputation ratings. Consequently, all of the 10 factors U.S. News measures, such as placement of graduates, quality of faculty, and the like, have virtually no effect on the overall ranks. It's pretty interesting. The deans got together in 1998, 164 of the 180 deans got together, and published a letter through LSAC to applicants saying, law school rankings may be hazardous to your health. And they explained why applicants should be wary of the rankings because they don't weigh factors such as the breadth and support of the alumni network, loan repayment program, cost, curriculum, clinical programs, quality of teaching, racial and gender makeups, etc. But law schools understand how this game is played, and they play accordingly. Most, if not all. The final thing I want to leave you with is, and I want to add one other thing about this. Make sure I have this right. Beginning in 2010 edition of America's Best Graduate Schools, U.S. News & World Report counted both full-time and part-time entering student admission credentials. And many theorize that this is going to have a similar effect in reducing diversity along many different contingencies, as have the overemphasis on the LSAT. Here's my final slide for you. One way to visualize the problem is to look at what we call shutout rates, which track the percentage of law school applicants from underrepresented groups who were denied acceptance to all of the law schools to which they applied. All of the law schools to which they applied. This looks at the 10-year period between 2000 and 2009, and you can see that the shutout rate for Caucasians was 31%. That is to say, 31% of those Caucasian applicants got into none of the schools to which they applied. 42% of the Mexican-American applicants got into none of the schools to which they applied. And 60% of African-Americans got into none of the schools to which they applied. All right, I'll give you one more image. I can't resist. Being a New Yorker, this is Carnegie Hall. It seats 2,804 people. These are the facts that roll around in my head. If you imagine the 8,500 people that we've gained in terms of added to the 1L classes over the last 10 or 11-year period, that would be a room 3 times the size of Carnegie Hall. And imagine that it's filled with 1L students, and that none, or almost none, of those students are African Americans or Mexican Americans.
And on that cheery note,
I'm very sorry.
I take the podium.
Let me undo some of this. Okay.
But what's so great about what Conrad said is I'm going to start my task, my very straightforward, simple task, is to explain why all this has happened. And he kind of ended where I want to start with U.S. News & World Report. So why have the number of African Americans gone down? Why have the number of Mexican Americans gone down? I posit a few reasons, one of which is law schools are chasing U.S. News rankings, and a law school dean that does not does so at her or his own peril. So it actually makes sense from a this is how the market works perspective to actually go after the U.S. News rankings. But I want to point out a couple of things. One, the LSAT is featured prominently in how U.S. News calculates its rankings. Diversity is not. Okay? There was a recent quote by Bob Morse, who oversees the rankings, who said something to the effect that putting diversity in the rankings would be complicated. Now, if any of you have ever thought about how U.S. News goes about calculating the rankings, it ain't any more complicated than what they're already doing. So it's just nonsense. It's like, oh, it's complicated. Well, yeah, so is the rankings, but somehow you manage to figure it out. So U.S. News so far has refused to consider diversity in figuring out the rankings of law schools. Second of all, with respect to U.S. News and World Report, the rankings and the LSAT score goes from the 25th percentile to the 75th percentile, which means those at the very top of the class, those above 75th percentile, and those below don't really count, which means law schools do have flexibility on who to admit. It's easier not to, but there is that flexibility. And the third thing I'm going to say about U.S. News and World Report is, if memory serves me correctly, this came out on an annual basis starting in the early 90s. 92. Okay, 92, because I remember being at George Mason when it came out. And before 92, let's talk about African American enrollment at law schools across the country. Numbers weren't that great. They just didn't have the law schools didn't have U.S. News to point at as the problem. Now, law schools say, oh, I'd love to, but U.S. News stops me. My response is, you didn't do it when you didn't have U.S. News. So talk is cheap, but I digress. Okay, so the second point I want to make why the numbers are so low, in addition to LSAT scores let me back up. The LSAT scores of African Americans is about 10 points lower than the average median LSAT score, mean LSAT score of whites. So basically, admitting an African American typically means admitting someone with a score that's going to be lower than the typical white applicant. Okay, so that's how we get into the problem. If you want a 152 or 160 LSAT, then there are African Americans who get 160. There aren't that many. If you look at the numbers, the pool of African Americans who get 160 or higher is very, very small. So one other piece of it could be financial aid. I was at a school that shall remain nameless that we found out it cost a lot more money to recruit African Americans than Asian Americans. So the then dean wanted to keep the minority percentages around 20%, and it would have been really, really costly to, because here's what happened. One year we had a blip year where we had like 28 28 students of color in the first year class, and like 22 of them were African American. And we busted the budget for financial aid, and we overspent. And the marching orders going forward was, you could do it this once, but you can't do it anymore. Well, how are you going to stay within your budget with a 20% student of color enrollment? Well, what this school figured out was we literally did not have to pay Asian Americans as much to come there, as we had to pay African Americans. So one potential reason why the numbers for Asian Americans we see going up could be financial aid costs are less. And schools that are trying to maximize the financial aid budget will pick student of color A, who may be Asian American, over student of color B, who may be African American. I also want to pick up on a point that Michael talked about. He doesn't like talking about pipelines. He wants to talk about rivers. And I agree with him. His point is that there's rivers that you feed into, it can move into something else, and as he describes, rivers can chip away at rocks. Okay, so we want to talk about rivers as opposed to pipelines that leak and rust and burst. So I would say the river needs work. And the river needs work, and I'm going to say something that's going to be a little heretical, but this is the last panel, I can run out afterwards, okay? The river needs work in terms of increasing LSAT scores of students of color. Nobody ever talks about this. Nobody really wants to talk about it. There's this disparity. There are 10 points less for African Americans than whites. Do I believe African Americans are not as smart as whites? No. Do I teach African Americans and white students? Yes. Do I see a big difference? No. So to me, the problem is the friggin' LSAT. But of course, LSAC isn't represented here, so I won't beat up on them too badly. But that's the problem. We've got a test with, in my opinion, a built-in racial bias. What do you mean a built-in racial bias? They've done all these tests, Dorothy. The LSAC has said their psychometricians have approved it. Yeah, right. Here's how I know it's a racially biased test, because blacks score less than whites. Okay? And I have these students in my class, and when I call on them, they're not given 10 points less on answers. Okay? So that's one piece of it. Now I'm going to move to the other piece of it. So I think the river needs work in terms of getting students of color to score better on the LSAT. So I'm going to bring in Claude Steele's work, right? Claude Steele says high-stakes tests, like the LSAT, is subject to stereotype threat. So students of color, African Americans who know the stereotypes, we're not as smart as whites, think this is an intelligence test and will score less because they think that. So there's work being done by Josh Aronson, who's worked with Claude Steele, and Rachel Gotzel, who's doing an LSAT stereotype threat study, and they're trying to come up with interventions that would actually increase the scores of African Americans. So I think that work should prove fruitful for all of us. The other point I want to talk about the river not working is achievement, law school grades for students of color. Right? Another dirty little secret we don't really want to talk about. But if you think about the earlier panels and who the law firms are hiring, and the law firms have hiring criteria. So if the hiring criteria is, you know, I've got to have someone on law review. Okay, then let's all ask ourselves, who are academics in the room, how many students of color are on our law reviews? If your law review looks like my law review, not very many. So what are we doing to work with our students to explain to them the importance of law review, to explain the importance of first-year grades, and to work with them to get it? I mean, I've done programs on my own on Saturdays for students of color, and by the time I left that school, the editor-in-chief was an African-American male. Okay, so it can be done, and that's why I know that the LSAT is a flawed test, because the LSAT had these students at lower scores than their white peers, but with some assistance, how to write an exam, they were able to knock it out of the park. Something else that's come up, Kevin Brown at IU Bloomington has written about this, and he talks about the diminishing numbers of African American law students versus Black American law students. So he's written about the fact that when you look at who's going to college, because you can't go to law school without a college degree, that there's an increasing number of Black Caribbeans, Black from Africa students in our classes as opposed to African Americans. So that may be something that will be worth future studying. The shutout rates, the first time I saw the shutout rate, 64% of African Americans apply, 42% I think of Mexican Americans apply to law schools, and they don't get into any. Okay, that's really scary. So the question is, why is that? Is that because they are on the low end of the LSAT score and therefore they're coming up against cutoffs? Or is it that maybe they're not getting the right intervention on which schools to apply to? So I would say, again, part of the river needs some work. Some of it's going to be racism, some of it's going to be shutout rates, but my guess is all of that 60-something% would go down if the students were counseled on which law schools to apply to, or different law schools to apply to. And then my final why could have something to do with the number of states that have adopted the Prop 209. You can't use race in consideration. So it started with California, and then it moved to other states, and there are movements afoot for it to go even further. So I think the big why is there isn't a commitment to do better. If I'm committed to 20% students of color, and nobody asks me to unpack that, I'm fine. Because all I do is report 20% of my entering class, and people go, wow, you're doing great work. But you want to find out which groups are being included. So one, I don't think there's a commitment. Two, I don't think there's accountability. So what? Our African American numbers are going down. Who's at the law school door saying to the dean, you better do better? Nobody. So part of it there's not a lot of commitment at the law schools. There isn't accountability for this kind of data being out there. And third, the law schools get to say, oh, it's U.S. News, I'd really like to do better, but U.S. News isn't going to let me do better. When, if you look at it historically, they really weren't doing better when there wasn't U.S. News. I'll end there.
I'm not going to speak again. I just was thirsty.
If you will indulge me, I would like to just remain here for my remarks rather than take the podium. I have a slight leg injury, so I'll remain seated. And I want to thank you, Dean Miles, for including me today. I want to thank the panelists who have preceded our panel and my colleagues for your remarks. I have the task of addressing solutions. And my colleagues, when we were planning our discussion today, nobody wanted solutions. I should have known that volunteering would present its challenges, but I actually think that most of us in the room know the challenges that lie ahead of us. So I'll try to articulate for you my thoughts on that, and I'm sure I will capture yours. I think of this as three strategies that we must execute simultaneously. Three things that we must do. Some of us will be doing all three of those at one time, and so we will be very good, juggling artists. Others of us will focus on one of the three strategies, perhaps more exclusively, but we must do all three at the same time. The first one is very obvious, and in my view, that's maintaining the status quo efforts that are underway to recruit students. So, how is this a solution? You think, okay, isn't that a little bit counterintuitive? You're saying maintain status quo. What I mean by using that phrase, maintain status quo, is that the efforts underway to get students into the pipeline or the river, however we wish to describe this. I actually prefer pipeline because it shows that there can be cracks in it. It shows that it can be full of sludge. It shows that when you get to the top, 60% and 42% don't dump out of the pipeline. So I like pipeline for all of the symbolism that it can bring to bear on showing the problems that we have. But we have 425 programs and counting at a minimum nationwide, which is really incredible. All kinds of programs, state funded, from firms, and so forth. And if you just go to the website for the Pipeline Diversity Directory, you will be impressed by what you see. And that, of course, doesn't capture everything. Just last week at my school, George Washington University Law School, we had a group I'd not heard of before. Maybe some of you have. It's called FAME, the Fund for Advancement of Minorities Through Education. They're focused solely on students in Pittsburgh. So we had 55 high school students at GW, and we were doing the normal drill. And I think in anticipation of this panel, I was thinking about this last week, and I thought, so many of us are at sort of, the 30,000 feet level. I mean, what do you do with 55 people? How do you connect with 55 high school students? So that challenges us to maybe do it on a retail basis. Connect with one student. If I took, for example, responsibility for taking one student who's in junior high now and mentoring that person through, that's not big numbers. But if everybody in this room and all of us concerned took responsibility for one person, that and all the things we need to talk about what that means, that they have to do, that might make a difference. But anyway, all of this still has to continue. And this is no small feat. Saying maintain status quo is no small feat. And let me tell you why. First of all, let's look at those funding challenges. State budgets are in disarray. So what monies are available from the states for these diversity initiatives? Let's look at our wonderful dear colleague, and I hope I'm not putting you on the spot, Cassandra Ogden with Clio, who is with us today. And how many of us in this room would be able to sustain the excellence of the programs that we have responsibility for if we had a 40% budget cut. 40% budget cut. Yet this miracle worker sitting in the back of the room has maintained her programs even though she's had a 40% budget cut since 2003. That is what I mean by maintaining status quo has to be a part of our solution. And there are no magic wands to wave. I mean, this is just in the trenches, hard work, and we have to refine it. We've got to tweak it to have success. And if we look at the conference report from November 2005, you might recall that amazing conference in Houston, Texas. Many of you might have been attending that conference where a report was generated with very good, solid recommendations about how to go forward. We don't have to reinvent the wheel. We can just look at what was done and published in an amazing report. It came out, of course, in early 2006 with incredible recommendations. One of the conference organizers, Carl Cooper, said it at the time, the biggest surprise is how many people there are in the nation that are committed to pipeline programs and who have not been collaborating. If we want to have more in terms of minority opportunities, we have to start to collaborate and to involve ourselves in urban education and public education starting from K through 12. So there's nothing new here, but we just have to continue this effort. In terms of that collaboration, we know there are new efforts that have sprung up. We know that there is that collaboration going on, but it's hard, and that's one of our strategies. We have to collaborate more. Finally, I think in this first category of maintaining status quo, I think we just have to take a step back, and we have to realize that these are tough times. I mean, the numbers are sobering. I mean, they make you want to cry. They fill you with despair if you let yourself go there. But we can't, because we know that we can try to turn the tide. There are the cynics who would believe if we put the effort into really helping students achieve higher LSAT scores, that what will happen? The test will change. It will be rewritten. And all of that effort will be for naught because there'll be a new test. And the new test will present the new challenges of figuring out how it's coded. So, but we can't give up. We cannot give up. The perfect is the enemy of the good, so we just have to do our best. I recall, this is just sort of I digress for a minute. In 1985, I was thinking about whether to leave the place of employment where I had worked with Dean Miles, the Federal Reserve Board, and I had family members in New Mexico, and they said, oh, you should come to New Mexico and work in the firm, and that they had just started. And so I was like, wow, this sounds really interesting. Well, then I probed a little further. I was related to 2 of only 7 African-American attorneys in the entire state of Mexico. 7. And I thought, okay, I'm not married yet. I'd like to date. So maybe my odds are this great. I kid you not. But it's improved. It's improved since then. But then if you also look at not all that long ago, there were only 13 minorities, however minorities are defined, only 13 minorities who took the LSAT in the state of Nebraska. Only 13. And you can predict that not all of them may have applied to law schools, and certainly not all of them would have been accepted, although if they applied in Nebraska, they'd be accepted since they're desirous of minorities. But those are bleak numbers. And so, yes, times are tough, but who could have ever predicted that we would have had the occupant that we now have in the White House, right? So anything's possible. And in August of this year, the Martin Luther King Memorial will be unveiled on the Mall. Who would have ever predicted that that kind of symbolism would be so present on our National Mall? So even though we are in the midst of this tough time, we have to look at sort of the glimmers of hope to inspire us to continue this heavy lifting. Okay, so more quickly. Secondly, what do we do while we're maintaining status quo and trying to keep, hope alive with getting students interested in school? Well, we have to address these obstacles to entry that have been so eloquently and so clearly defined for us this afternoon. First, with respect to the LSAT, we do know that the ABA announced just in January that they're going to review Section 503, right? So you say to yourself, so what are their conclusions? To say, let it be the choice of the schools, we're not going to mandate it anymore? Could that be a good thing? Because schools are still going to use it, or they're going to find something to use. So what should our position be? Do we encourage this because we think if it's somehow diminished in being the be-all and end-all, that helps us in addressing the real qualities of our students that we want in our schools? Is that going to help us? I don't know politically, what the right strategy is there, but it's something for us to address. Then you see some schools who take we won't, be beholden so exclusively to the LSAT. We'll deviate. By golly, we'll deviate. And so, what are their plans? Okay, so I can dump on my alma mater. So Georgetown has their early assurance program. If you have a 3.8 GPA from Georgetown undergrad, you can get into the law school without taking the LSAT. So if you have a 3.8 undergrad, you can take the LSAT and you'll do okay. So that's not all that great. Same for the University of Michigan. They have the Wolverine Scholars. Again, 3.8 is the magic GPA. If you have a 3.8 from the University of Michigan undergrad, you can apply and be accepted automatically into their law school without taking the LSAT. Well, what did they do? I see a hand.
You can't take the LSAT.
You can't take, yes, thank you. You're not allowed to take the LSAT because they don't want to have any evidence, right? So, so then the Dean of Admissions says, because she was roundly criticized for, you're just gaming the system. And she said, no, I'm not gaming the system. You see, there are only 200 juniors at the University of Michigan, a very large state school, who even qualify with a 3.8. And of that, we may take 5 or 10 people out of a total went-all class of 360 students. No gaming here. So how many of those students do you think are going to be students of color? How many? Okay, so these aren't really great solutions, but at least people are trying to think outside the box a little bit. Then you look at the other end of that. The Massachusetts School of Law in Andover and the University of Illinois College of Law, they just dispense completely with the LSAT. And they say we're going to do interviews and we're going to look at an essay test. And that's how you get in. So how has the ABA rewarded these schools for their innovative thinking? They are denied, as Susie Orman would say, they are denied accreditation. They are not accredited. So would we advise a student of color to go to that school if it's not accredited? I don't know. So issues with the LSAT, but we have to keep pushing at that. Other obstacles. This U.S. News stranglehold is really frightening. Yes, a magazine, really? Really? But yeah, and frighteningly so. The people who spend hours and hours agonizing over the numbers and the formulas and falsely reporting the stats, it is shameful. And you're so right. How, looking at these, we couldn't possibly count diversity. Please. The formulas are amazing. There's studies of useless news and world retort and how they do their numbers. So is it possible to break that stranglehold? Is it possible to find a competitor magazine that would engage in real analysis and then have a pact of all law schools that one year just go to the competitor magazine? Don't even play with useless news and world retort. I don't know. But, could we do that? This is more radical. And the other barrier that has been discussed, of course, is cost. Cost is prohibitive for so many of our students. So the good news is I got in. I wasn't one of the 60% who didn't get accepted anywhere, but the debt burden is just burdensome. It is crushing, and there's no more big law to bail you out, right? And so you really want the public interest job, but the big law people have taken those jobs, so you're left with your debt. That's the property you have, your intellectual property, is in lieu of a mortgage for a real home that you are purchasing, because you cannot do that for many years. So, but we have to push against this. We have to look at funding. We have to look at scholarships and raising funds for scholarships. We need to look at ways for students to maybe go part-time and work and make their schedule work for them so that they can really do justice to their studies while they are working at the same time, but thereby decreasing costs. There are ways for us to try to push and address this. So mind you, we're maintaining status quo, we're doing all of our programs, even though our pipeline is just as kind of yucky as it could be right now, but we're going to do it. And then we're going to push against the LSATs. We're going to push against these mindsets that are so destructive. And then the last thing I propose in terms of a solution is that we really begin to create what I call a new century paradigm. A new century paradigm. So what would that look like? Okay, so here we are, it's 2011. It's 2011. So let's say that the children born in 2011 are going to go to law school. So by my calculation, they would enter college in 2029, right? So 18 years out. And one of the tenets of my belief of a new paradigm that we have to instill is that we should encourage our students of color not, I repeat, not to start law school right out of college. Do not go straight to law school. 2 years, 2-year break. And the 2 years has to be filled appropriately. I mean, working at Starbucks, maybe not, but something, that is filled substantively in the 2-year period to prepare you for law school. So that would be one of the key tenets of the new paradigm, that we would collectively agree that we would advise high school and college students to think of law school 2 years out. Borrow from the business school model. Business schools don't let you start right away, right? You've got to show that you know something before you can go to B school. So we should adopt that. And in fact, Northwestern University Law School has that model very clearly. They have a strategic plan that says, we're not taking you. Goodbye. Don't even knock on our door. And so you don't get in. But 2 years later, okay. And they've got a decent track record on diversity. I mean, relative to the indecency, right, that exists. So 2 years, 2-year break. So what would happen? You have to fill that time meaningfully, and of course there are issues with that. Jobs are scarce right now, so fine. I tell a student, don't apply to law school now. Wait and get yourself ready and go 2 years later. But there's no job for them. So what are they going to do? Like hang out at mom and dad's? So right? So then you say, well, what about undergrad loan repayment? If your loans are coming due, how do you manage that? So then maybe we look at things like Teach for America, where we can take our students, they're productive in our inner cities and in other places, they're getting good skills, they're serving the community, they're getting the problem, because they've at least made it through college. And they may be working with some students who aren't going to make it through high school at the rate they're going. So that would help, perhaps, in awareness and in future willingness to be a part of the solution. There are other opportunities for volunteering where you get valuable experience that looks great when you're applying for a job. Maybe you can focus on some of the business courses. Our colleague, Ms. Parham, spoke so eloquently about the need to focus on the business model. Are there business courses that you can engage in? Could you work to gain a greater understanding of contracts so that course isn't as mystifying to you when you're in it? So the other part of the paradigm would be to truly focus on what I call the 100 days, the first 100 days. Because as we know, the grades matter when you're a 1L. And it's really the first semester, because if you're really in the tank after your first semester, think of the heavy lifting that the second semester has to do to boost that GPA. You come out with a 2.0, 2.3 your first semester, then your second semester, what do you have to get to even have a sizable bump to get you close to maybe a 3.0? So it's impossible. So if you think of it, when a student comes into law school, if you look at September, October, November, and the early part of December, that's it. That's 100 days. So we need a strategy. We need a strategy in our new century paradigm of the first 100 days. That's why we have a problem, because they don't get that it matters until they see their grades in January, February, right? And it's too late. They've lost the game. They've lost after 100 days, and nobody tells them. So the prep comes in before that time. So what can we do with college curricula to try to change pre-law so it's not all philosophy and English, right? But really prepare them, and then work with high school guidance counselors and college guidance counselors, right, who are, no offense to those folks who are in the trenches, but some of them just don't know. They don't get it. So it's our job to teach them, because they're not going to learn it any other way. We have to prepare high school and college guidance counselors to get it and to steer them into the right courses. And then we have to look at our law school curriculum. Our law school curriculum needs to be revised, and that's a whole other panel, a whole other conference, on law school curriculum. We've all been in those discussions, but we do need a new law school curriculum. Other things we can look at, even in law school, depending on policies at a school, can a student take a year's leave of absence to then gain perhaps some valuable experience and come back and then maybe really do better as 2Ls and 3Ls? Take a hiatus so they don't march straight through. That has implications for a law school budget. Believe me, I understand that. I work those numbers all the time, but there are ways to help our students to be prepared when they graduate. And then just a couple of other quick points. Finally, I think that it would be really wonderful if we could address some of these issues in addition to this wonderful forum with our two White House lawyers. Could you imagine a White House summit on the status of minorities in law school? And you would have the President and First Lady, who of course were in the stratosphere at the top tier school, but able to get it and able to perhaps address some of these issues. So might a White House summit, when would we ever have the time again to do that at such a visible level? So maybe that could be something. They do lots of summits, as you know. They just did the summit on bullying, and there's a lot of engagement on issues around education. So we just have to get our issue in front of them, right, so that they will agree that this is a good idea. And then, have all the right people there and, great publicity, and launch our new century paradigm by that great, lofty White House. So just some ideas on what solutions might be, as heavy as the lifting is, and as steadfast as we must be with this, to take the long view for 100 years, 200 years down the road. This is not a 5-year problem.
Thank you so much to our excellent panel. We are going to open this up for Q&A, and if I could jump in and just put one question of my own, primarily to Professor Johnson. I thought what was interesting is how you took the minority representation, you sort of disaggregated that number, and you looked at African Americans and you looked at Mexican Americans. And when I think about law school today, even when I was attending, I think there's another group that you could further disaggregate. I see a distinction between black males and black females in terms of representation and coming out of law school successfully. And I'm wondering if you can speak to that, if you've seen that in your own data, or if there are any ideas in terms of why we see that kind of disparity as well.
Sure. I can't say I've studied it extensively, but I took a look at the ABA has a spreadsheet that I think reflects, as I recall, the enrollment in 2008, and it's broken down by school and by lots of different categories. And if you analyze that data a little bit, what I see is for African Americans, 2/3 of the African Americans in law school, at least in 2008, as I recall, were women. 1/3 male, so 36% were male. For Mexican Americans, slightly more, 51% male than female. And for whites, there were 56% were men and 47% women. So that's what I've seen so far.
Could we look at also those minorities born and raised in this country compared with minorities?
The figures in that spreadsheet don't break it out that way, so I couldn't answer your question.
Anecdotally, I think there is a discrepancy that those who grew up in a foreign culture do better academically.
Well, it's an interesting point that you raise. Dorothy, you raised the point about Claude Steele's work. Claude Steele is the provost at Columbia, and one of his proteges, Valerie Purdy Vaughns, is a professor of psychology at the university. And she and I have begun an actual working relationship with a New York-based pre-law institute to try and see if we can use the interventions there to make a difference. And one of the things that I've learned as a result of that is that this stereotype threat tends to work more the longer, if you're African American or someone who has African lineage here, tends to work more aggressively against you the longer you're in the United States. So if you just came over, it probably ends up affecting you less, at least statistically as I understand it, than folks who've been here all their lives.
Question? Yes?
I thought the presentation was phenomenal. Thank you very much. And I have many questions, but since I'm on the law firm side of the issue, I wanted just to focus for a second on the stats, and I apologize in advance if my questions just show my ignorance, but the Mexican American community is just a community within the larger Hispanic population. So one of two questions. First, why the focus on the Mexican American community, and how they consider the other Hispanic communities? I wonder whether the statistics would have been better or worse.
It's a good question. I separate out the categories simply because those are the categories used in the data that I was studying. That is to say, those were the categories used in the LSAC data. So that's when you look at it across with that window, that lens rather. That's the group that falls out as doing markedly worse than the larger category of Latinos generally. And it's really an interesting question, and one I don't have an answer to as to how does that really work out in terms of how people identify or the like. But using their statistics, that's the way it plays out. And I think since my mission was just to look at the stats and to try and see, with the sort of finer focus, what's happening within the minority community, that's one of the things that turned up.
Yes. Richard.
Hello. Thank you so much to the panelists for speaking. I'm Lee McGuire. I'm a 1L here at Catholic University.
Woohoo!
This panel honestly just sort of felt like a breakup. It's been really heartbreaking, but I think the next step is to move on. And I think as a student, I guess my question is directed towards Dean. What is it that current students can do, of African American descent or who identify with minority status? What can we do while we're here in this institution to make sure that we're assisting in these solutions that you propose, and making sure that we're looking back as well as looking forward to close the gap?
Well, wonderful question. Congratulations on being a 1L, and that's just great, and wanting to reach out. So the first thing I'll say is any of those efforts have to be in context of the time constraints you're under. Because so many students of color feel that need to reach out and do things and to sustain that. And it's okay if that takes a little bit of a hiatus, at least as a 1L, maybe when you're a 2L or a 3L. And I know you have to maintain your sanity, right, and keep those outlets going, but your best effort as a 1L is to be an example of somebody who crosses the finish line, right, with the options open to you as you keep going forward. Then as a 2L or a 3L, I would say reaching back to college and high school students, because they will relate to you much better than they will relate to me or others of us who have a few more years on you. And so that effort to tell them what it takes, how hard law school really is, the amount of time necessary. There's none of this the night before sort of cram and then show up for the no. So that kind of effort of reaching back and telling them what it takes to be prepared, they will listen to you. And there's lots of ways that you can do that. Lots of programs to make it easy.
Okay, in the back?
There's been a lot of discussion today on things like LSATs and GPA working in schools, and I'd like to hear your observations and about what schools can be doing better to prepare students for the bar, which is a big issue in diversity, and what even perhaps the legal community as a whole can do to handle issues between the intersection between diversity and bar passage.
Since bar passage wasn't on our agenda, here's what I'd say. It's my understanding that bar prep courses work. So the problem is a financial one, because they're not cheap. So if you were asking me what could a law school do to address that, it would be to provide financial assistance for their students to take bar prep courses. I know there have been some law schools that have had bar passage problems themselves, and they have kind of run their own program, which is really expensive. But I don't believe in reinventing the wheel. I don't believe law schools should get in the business of putting together bar prep courses. So my thinking is there are bar prep courses out there that seem to work really well. And if that's something that's a problem at the school, we should raise the money or do what we need to do to send students who don't have jobs, whose firms aren't paying for it, to get bar prep.
Can I add very quickly to that, too? There's a big elephant in the room, and that's Barbary. They have the monopoly, at least in this region, on most students paying for Barbary courses. There's more than one bar review that could be best for a student. For example, in the state of Maryland, there's and I don't get paid by them, I don't represent them, but I'm just letting you know that Shermer Bar Review takes a different approach to learning styles, and some students learn differently, and that's fine, and they work with that. And some students find that form of bar preparation is much better. And then finally, there are those who really would benefit from having a tutor to help them get through the bar material.
Yes, the back.
Thanks to all of you, this has been a fantastic panel. As educators, I really would like your opinion and guidance. I work in a law firm, and I run a summer program for minority college students who are matriculating either the following fall or 1 year later at law school. And one of the questions I get every year is, which path should I take? Should I go all out, go $200,000 in debt, and go for the highest ranked law school on the U.S. News and World Report? Or should I go for a school where I can reasonably afford, understand that I will have to go into debt to a certain extent regardless, and get an education there, because I support my parents, I support my children, I support my family, I have to work, I'm the only person, etc., etc. So I feel constricted in what I can tell you, because I know how, for lack of a better word, it is our profession can be. And I was was fortunate enough to have gone to a top-ranked college and law school because my parents could afford to help me out. I'm still paying off six-figure debt, and they helped me, but that's an aside.
But I digress.
So what should I tell them? Because I want to tell them what's best for them.
Can I give it a shot? Because I get that. I speak to a lot of. You wouldn't think so, as depressing as it was. And I speak to a lot of student groups, and my goal is not to depress you. I'm sorry, I have. That's rewarding. But I just traveled all the way to Washington to depress a 1 hour. But my goal is to sober people up a little bit and have folks who are more at the gatekeeping end say, wow, maybe we're not doing everything we can. But my answer is, I get that question a lot, and maybe it's because I'm a clinical teacher, but the answer really is, it depends, right? It depends what kind of work you want to do. If you're in New York City and you want to be a district attorney or work for the city or be with the Legal Aid Society, you don't have to go to Columbia to do that. And if you got into a state school that had lesser tuition, you'd probably be okay. Things are changing somewhat, and so there is this way in which the rich keep getting richer, but I still think that could be true. If you want, where do you want to practice? Do you want to practice in Iowa? Well, go to Iowa, all right? And go to the law school that's best for you in Iowa, or that prepares you in that way. What area do you want to practice in? Well, where are the people who have connections in that way? And where could you get mentored in some way? That will make a difference. And so I don't think there's a real hard line, hard and fast rule where you'd say, look, go to the highest ranked school. Because I don't believe that much in the rankings. I believe it turns out to be more about who you know, what you want to do.
And I get that question a lot too. And I do think that there's no one right answer. But here's what, and most of the questions you asked, entering 1Ls don't know the answer to. They don't know where they want to practice. They don't know what they want to practice. They don't know what they want to do. Okay, so my big picture is to make yourself as marketable as possible. So there's a trade-off, right? Okay, so you can come out of a lower-ranked school with less debt, or you can go to a higher-ranked school with debt. If you want to work in big law, that's a big difference. Because from big law's perspective, if you're at the higher ranked school, their cutoff is going to be lower in terms of GPA than if you're at a lower ranked school where their cutoff is going to be much higher. So I have that kind of a discussion with the student to talk about, well, if you want to make yourself as marketable as possible, I think it's still true for students of color, especially African Americans, to go to the highest ranked law school you can get in. And David Wilkins and Mitu Gulati have written a lot on this. However, is that to say that going to a state school and graduating the top of the class, you won't have as many opportunities? No, you will. What are the odds that you're going to go to the state school and graduate at the top of the class, right? So you're trying to give them advice when they probably can't answer all the questions we need answered at the time. And my default rule is what will make me more marketable. That's been the best advice I've ever gotten career-wise. But of course, I graduated Georgetown in '83. I went into Georgetown with $3,000 of undergraduate debt. And I graduated Georgetown with $20,000 of debt. And it's long been paid off. So, 200,000, crazy talk.
Okay, I think we have time for one more question. In the back, yes, in the front.
I work at a pipeline program with high school students nationally. Now student level literacy program. One of the questions I get, I graduated law school in 2009, and I talked to my friends, my classmates, many of whom don't have jobs or have a long time finding jobs, and they tell me, so do you encourage students to apply to law school? And I say, yes, I do. And I guess the question I have is, with this Carnegie Hall is filled with students finding a job in this market?
You know, again, the best, and I'm a tax law professor, so I practiced tax law and I was an investment banker on Wall Street. The best advice I ever got was you only need one job, i.e., I don't need to get myself a job. I don't have to get me and all my friends jobs, right? So, because people get overwhelmed by the data. I knew I wanted to be a lawyer from the time I was 5 years old. So I was going to do what I needed to do to get in there. If I will say this, law school as an option when I don't know what to do is no longer a good option. But I'm guessing that the students that you're mentoring actually want to be lawyers. Some of them, okay? Well, then they need to think about whether they want, because it's 3 years of hard work. They may not want to put in the time to do that. But I think this gloom and doom overstates the case that in this gloom and doom, people are still getting jobs.
I would also say one other thing. There was a great seat. Well, it's not a seat. It was an album back in my day called Swiss Movement. It was by Les McCann and Eddie Harris. And the big hit from that album was Compared to What? So I sometimes ask students, okay, I'll bite. You know, I do agree with the idea that you shouldn't go to law school. I think Mr. Stander mentioned this earlier, if you don't really want to go to law school. But I think that was true all the time. And so I wonder when students ask me that question, well, what else are you thinking about? You know, compared to what?
You can tell them that it prepares you to be a community organizer in Chicago, right? And a senator, and other ways to apply the law degree, because your critical analysis and reasoning ability can be applied in policy positions in numerous ways. And so if you really want to go to law school, then students should not be daunted by finding a job. I would concur. You can find a way to apply those skills in other venues so that the effort is worth it.
Thanks so much to this panel and Professor Malveaux for moderating. On behalf of Dean Miles and the law school, I want to thank you so much for coming today and participating. I thought this has been such a great discussion today, and I want to particularly thank the panelists who not only came here today to deliver the message, but were so critical in the collaboration of what today was. I want to announce a couple things. Number one, the entire proceedings today, including Professor Olivas's fabulous keynote, were taped and are available on the CUA homepage if you know folks that wanted to attend and weren't able. And additionally, we have a transcription service here today who's taken a transcript of what happened today, and I'm going to be working with Dean Miles and other folks to put together a special report on the conference. But it's been a fabulous day, and thank you so much for coming. Have a great weekend.
Website.